Hello and welcome to the big picture. The concept of privacy is something which has been debated about all around the world for decades, if not more. In a democracy, right to privacy is something one covets. But a serious question has arisen about it in India, with the Attorney General of India telling the Supreme Court yesterday that right to privacy does not exist in India. He pointed out that Constitution does not bestow it as a fundamental right and even referred to a 1950s judgment to buttress his argument. This assertion of the Attorney General came during a hearing on a batch of petitions challenging the validity of the Aadhaar cards and its potential to intrude into the privacy of the individual. While the judgment on the petitions will come about in some time and the future of Aadhaar will be decided, the question is, where does right to privacy begin and where does it end as laws and statutes stand today? What is the concept of right to privacy, and especially in this digital era with information technology ruling the roost, how is one's privacy assured? It is also important to note here that the previous UPA government had come up with 2 drafts of a privacy bill, the last in 2014, which is yet to see the light of the day. We will discuss all this today with Soli Sorabjee, an eminent jurist and former Attorney General of India, Justice B.A.Khan, former Chief Justice of the Jammu and Kashmir High Court, Professor C.Rajkumar, Vice Chancellor of the O.P. Jindal Global University, and Satyaprakash, Legal Editor of the Hindustan Times. Welcome to all of you. Mr. Sorabjee, when the Attorney General says that, there has been no right to privacy in this country, in the 1950s, the Supreme Court, in a 8-judge bench, I think, had ruled this. So where does this whole issue of privacy stand in India today?
Well, I wouldn't like to comment on the Attorney General's statement because it's in court. But the question is, privacy has 2 aspects. Privacy in respect of a private individual has different dimension. Privacy in respect of public officials has a different complexion.
Right.
Actually, all around the civilized world, it's recognized that the right to be left alone, that's the most cherished right in a civilized society.
Right.
If some private individual is concerned, you can't ask him, have you any illness? Have you got diabetes? Have you got thyroid? Who's your doctor? What's the injection you're taking? Who are the friends you're meeting? No intrusive as far as his private life is concerned. As far as the public officials are concerned, it's a different thing. It may make us, because there he's meeting certain friends, going to certain places, going to certain clubs, may have some impact on the discharge of his official functions. So therefore, in the case of a public official, the protection of privacy is rather thin and has to yield to larger public interests. Now, as far as the Attorney General is concerned, all I can say is I don't agree with him at all. Thereafter, there have been judgments of the Supreme Court. It's true, privacy is not expressly mentioned in the Constitution. But there are so many rights which are not expressly mentioned. Freedom of the press is not in the Constitution. But it has been deduced from the guarantee of freedom of speech and expression. Like that, privacy has been deduced from other provisions, and especially from Article 21.
Right.
And, well, as I said, matters before the courts, I want to go into detail, except to say I'm in total disagreement with the statement of the Attorney General, whom I greatly respect.
Okay, but sir, this whole thing has come up in the context of Aadhaar, in the context of the Aadhaar which has been issued apparently to 800 million citizens in this country, 800 million people in this country so far. So in that context, would you like to say that this concept of how this concept of privacy will affect as far as the Aadhaar cards are concerned?
Is it to me?
Yeah, it is to you, Mr. Sorabjee.
Hello?
Yeah, to you, Mr. Sorabjee.
Oh, well, okay. Well, if Aadhaar requires, or rather warrants intrusion in the private affairs of an individual, then it certainly affects his right to privacy. Because it may be, as I said, in the case of a public official, please keep the distinction in mind. But as far as private individual is concerned, Aadhaar certainly affects his rights of privacy, and to that extent, it has to be justified by law.
It has to be justified by law. That's very interesting, Justice Khan. The fact of the matter is that Aadhaar is not based on a law. There is no legislation backing this, collection of the individual's details as far as Aadhaar is concerned. In that context, and also in the context of what the Attorney General has asserted in the court, now, right to privacy, where does it come from?
Article 21, obviously.
So, but as Mr. Sorabjee also has pointed out, and as the Attorney General also pointed out, is it just derived from the Article 21 from right to life and liberty?
Oh, yes. See, Article 21 has received such an extended interpretation post Maneka Gandhi case that everything under the sun which concerns a individual's life and liberty is sought to be brought in it. For example, you may not have explicitly mentioned in the Constitution, for example, right against, say, pollution, good environment, drinking water, education, so on and so forth. The whole thing has been interpreted from the words life and liberty, and life to be lived in reasonable and fair conditions with dignity. Now, that interpretation holds good today, and it's no good to say that some 8-bench judgment in 1954 said that it was not a fundamental right. At that time, the conditions were different. Constitutional law had not evolved as much as it was in the changed conditions. And after that, we had, for example, in Khadak Singh's case, it started the Khadak Singh's case where the surveillance issue came in. And thereafter, in every case, there has been a multi-dimensional extension of the concept of life and liberty. Therefore, even if it is not explicitly mentioned in Article 21, it is implied, it's implicit in the concept of life and liberty, which is guaranteed by the Constitution, subject, of course, to the procedure established by law. So it's not an absolute right at the same time. See, just as any fundamental right is not an absolute right. Subject to reasonable restrictions, of course. Now, as far as Aadhaar card is concerned, see, it will all depend on what kind of an information is sought to be from the person with regard to Aadhaar card. Now, suppose that information has nothing to, which tantamounts to an intrusion into an individual's private life, then it may be a good thing. It may not be a violative of any fundamental right at all.
It may not be.
Yeah, in case, it depends on the nature of it. And that nature has to be determined again in the court. Now, since right now the matter in the court, it will not be proper to comment what is the nature of information sought, how is Aadhaar concept or Aadhaar card intrusive of a private individual's privacy. So it will all depend on what kind of information is sought, whether it is violative of that right or not. But as far as Attorney General's statement that it's not a fundamental right, that seems to be a very superficial interpretation of the provisions by saying that it is not a fundamental right. It's not given there. It's not in the Constitution. Yes, it is not in the Constitution.
Everybody knows.
So, or not so many things. Freedom of press is not in the Constitution. Yes. But Article 19 was interpreted to include freedom of press.
Right. Okay, Dr. Rajkumar, in the context of Aadhaar, and when we have this kind of arguments being made, how does it affect the this whole atmosphere?
Well, one of the most important things about interpreting the Constitution and looking at how it affects, say, public policy, in this case, what the government is attempting to do is to develop a public policy framework of introducing identity cards so that the public services can be given in an efficient and effective manner. Now, it's rather it's not an appropriate argument to make that it is not a fundamental right. In fact, it's not only so many judgments have expressly said it in some ways, or have infused the broader interpretation of it to infuse privacy into it, right to privacy. However, balancing is part of the constitutional evolving process. So in a way, what will have to be done in this case is that whether the restrictions imposed in relation to the right to privacy is going to be undermining the right to privacy,
That is
and
exactly
to what extent Aadhaar card and the information collected by the government is going to intrude into the privacy.
Let me just tell you what is it that the petitioners who have gone before the Supreme Court, challenging the validity of Aadhaar say. They say that the biometric identification denoted for UID, namely the iris scan, fingerprint identification, the personal details collected can easily be misused by can easily be misused.
So that's in fact, there is one problem in that argument. The possibility of a misuse of information cannot be a sufficient ground for negating the very existence of such a policy. Let's go back a little bit. Historically, governments have always collected different types of information of people, and every collection of such information does intrude into the privacy of individuals. For example, census information, that collects information, driving license, passports, bank information, all these things consistently collect information which are at times private in nature, hospital records. So the question is not so much in all these gathering of information, there is a possibility of misuse. But I think the more nuanced argument that is being made here, it seems, by the petitions is that not only the mere collection of information, but they're also making an argument that this information is not collected properly. There is a sort of a disorganized and a lack of checks and balances based collection. There are private, potentially commercial entities, including organizations which are not being properly monitored by the governmental system, which are collecting information. And that risk of this information being collected in a rather cavalier manner runs the risk of undermining the privacy. Now, the best response for that, frankly speaking, from the government standpoint, would be that they are indeed having sufficient checks and balances
that is
put in place.
That is the keys, the sufficient checks and balances are there. Satyaprakash, why do you think, how is that? See, this is a case which started sometime in 2013, 2014. It was during the previous government. Is there a consistency in the way the governments have made their points in the court?
This is a typical state acting in a typical manner.
It is not
about one political party.
Which party has been in power?
It is about the state,
yes.
The nature of a state. And the nature of a state, ever since the state came into existence, those who have studied social contract theory, they know that how society surrendered certain rights in favor of the state in lieu of security. But the state always would try to intrude. The problem is that now we are run by the Constitution, which guarantees right to life and liberty. What is the problem? The problem is Article 21 says, no person shall be deprived of his right to life and liberty except in accordance with procedure established by law. What is lacking here is there is no law authorizing the government to collect these kind of intrusive data. If there is no law, you cannot do it. And whether it is intrusive or not, it is from the facts of the case, we can easily collect, because fingerprints, biometric details, these are all intrusive data. And if somebody misuses, but misuse is secondary argument. The primary argument and the legal argument, constitutional argument is that you cannot collect these details without there being a law authorizing you. The procedure part is lacking, and hence the government is And so far as Attorney General's statement is concerned, I don't need to comment on that. Already everybody has said that that is wrong. Constitution is not a dead wood. It's a living document, and it is interpreted in accordance with the needs of the society and
needs of the time also.
Needs of the time also. To say that right to privacy is not a fundamental right, this is.
It's like going back some 100 years.
Yeah, and some judgment in the 50s or 60s, even if the Supreme Court said, but then there are subsequent judgments of the 70s. Menka Gandhi case is there, 90s. This PUCL case, phone tapping case is there. And now to say that it is not a fundamental right, and that to justify collection of intrusive details for Aadhaar. Nobody is against Aadhaar per se. People are opposing it, and there are jurists also who are petitioners in this case. They are opposing it because there is no law authorizing the government to collect these data.
Okay, sir, Mr. Sorabjee, there are two things which I want to know. One is that the Menka Gandhi judgment, which you spoke about earlier, it clearly says that there has to be a a prescribed procedure needs to be there. The procedure must withstand the test of one or more of the fundamental rights conferred under Article 19, which may be applicable in a given. And 3, it must withstand the test of Article 14. So as far as Aadhaar is concerned, is that the major problem there? That there is no procedure established to collect this kind of information, and so whether it can be misused or not is a secondary issue.
The main question is, where is the law? You can't do it by just government policy. As someone rightly said, there should be checks and balances, provision against misuse, safeguards, but it must be a law. You are forget fundamental rights. Are you not affecting the right of an individual by getting all this information? Where's the law authorizing you to do that? That's the first requirement. Then we'll test the law on the ground of unreasonableness or otherwise. Here the basic flaw is absence of law, no legislative sanction permitting all this kind of intrusive inquiries. That, to my mind, is the main flaw.
Okay, and Mr. Sorabjee, also another thing is, in this era of information technology, when things are available on the, at the press of a button, how do you ensure privacy? What kind of tests need to be employed to ensure privacy in this era? The Information Technology Act has come, has certain provisions to it, but you think that those provisions are enough?
Well, no, it depends, yeah. It depends about what's the nature of information in respect of which information is claimed, nature of the activities. As I said, please make a distinction between a private individual and a public official. The basic concept of privacy is the right to be left alone.
Okay. Sir,
Don't intrude in my private life.
Absolutely. Yes, Raj.
But if public official is concerned, that's a different matter.
Absolutely. Yes, Dr.
I just want to mention that it is entirely possible that we can justify the fact that there is a constitutional right to privacy and yet uphold the constitutional validity of the Aadhaar card. I also don't believe that for every aspect of public policy, including a policy of the kind that the government might initiate, you don't require a law, because the provision also talks about a procedure establishment law. There are lots of policies, rules, regulations. The government is, you cannot run the government and in many ways restrict the ability of the government to formulate policies by requiring that every aspect of that policy will have to be passed through a law. And governments all over the world, including in India, doesn't function like that. But here, one important aspect which we should bring in is that whether having an Aadhaar card is a compulsory requirement or whether it is registration is part of a non-mandatory framework, because mandatory or non-mandatory.
Supreme Court has already given a stay order on making it mandatory.
So for having a non-mandatory requirement of a non-mandatory registration of citizens' identity, I don't believe that you require a law, because there is enough policies and procedures in place which the government bodies can initiate it. I mean, all the time, ministries of governments, all the time are initiating
keep on collecting information all the time.
Lots of policies.
That's an interesting argument he has, Justice Khan.
Girish, I would tend to agree to that extent, to some extent. See, because the problem just now is that we don't have the whole material or data before us. What is this Aadhaar business all about? And what kind of an information is sought, and to what extent that information is intrusive to a privacy rights of an individual. So, for me, it will be just now prejudging, because we have nothing to suggest. For example, if simple information is sought on various issues from an individual, which is required for any administrative purpose, and which does not militate against his privacy or
of being left alone.
Yes. Then there is no need, as Dr. Rajkumar says, then there is no need of a law. In case that action deprives a person of some right, then only you need a law for that. But in the absence of what Aadhaar card seeks, And in the absence of any material, which may be perhaps before the court, but which is not before us, it would be prejudging the issue and to seek that there must be a law, and minus that law, any information sought. For example, for your birth certificate, you may seek some information. For passport, you may seek some information. For your ration card, you may seek some information. Should we have a law for all that information? See, you need a law only where a person's right is, if he is deprived of a right.
Could be deprived of.
Could be deprived of a right. So, in the larger interest, for example, of the state, of public interest, of national security and issues on that, so there can be actions of the government, there can be policies of the government, as Dr. Rajkumar was suggesting, which can lead to seeking some information.
Okay. Yes, Mr. Sorabjee, you want to intervene?
I want to make a distinction.
Yes.
You're right. Every policy doesn't require a law. For example, policy whether we should paint the building yellow or green or red. But any decision, either policy or otherwise, which affects the rights of a person, forget fundamental rights, affects the rights of a person, requires the authority of law to support it. That's the doctrine of the rule of law, which you have followed. Irrespective of fundamental rights or not, if you want to affect anyone's rights, first question is, where's the law? You can't do it without a law. Policy matters are different. We do not affect a person's rights. As I said, we want to paint a building in green color or yellow color. No one's rights are affected. But if rights are affected, the first prerequisite is we must have a law.
Okay. Yes, Satyaprakash.
Yeah, I was saying what the government did. Initially, they said it is not mandatory.
Yes.
It is to enable people to avail of certain government schemes and welfare
And it is purely on
but even
voluntary basis.
Voluntary basis. But even after Supreme Court said you cannot make it mandatory,
Yes.
the government has been advertising in various newspapers
Right.
and various other forums.
And some state governments are also making it
saying
mandatory.
that you will not get it if you don't provide Aadhaar card.
Right.
This is mischievous, and as a freedom-loving citizen, I would say it should not be done. And I completely agree with Mr. Sorabjee. If it is not any policy, it is a policy or a scheme which actually affects your right. If it affects your rights, there has to be a law. Without law, you cannot touch that.
Absolutely. But Justice Khan, the question is, there is a conflict now between privacy and transparency. On the other hand, we have, there is a lot of, much is being said, and, it has also helped the people of the RTI, for instance, the Right to Information Act. And on one side is privacy and the other side is RTI. Or, the issue of transparency. How do you resolve this?
Girish, I think in this digital age, there is hardly anything left of this
Exactly.
right of privacy. Surveillance, your iClouds, your whole thing is being monitored somewhere and you don't know about it. And the whole concept of this individual's privacy, which may be protected, unless it is protected by the protective of privacy, and there are some protective laws which have to protect. For example, take for example net. You are all mail, you are all correspondence, you are all family, you are all activity within the house.
Yes.
For example, if you are watching pornography, even that is monitored somewhere.
It can be monitored.
Monitored somewhere. So, in the light of all that, there is a need for some protective laws which can, in fact, protect an individual's right of privacy. And those protective laws, as you just now mentioned, that some bill was brought in.
Privacy bill
was in even 1914. This is something like your this broadcasting regulation bill,
right?
Which never sees the light of the day. Similarly, this privacy bill also will not see the light of the day. See, the most advanced societies like United States, even they have been struggling with this privacy rights.
To ensure privacy.
Right from Warren days in 1960, till they came to justifying this abortion as a private right, for example. Even watching this pornography in your home, they protected by Supreme Court judgments. So that law is still evolving there. We are still at no stage, unless we become very conscious of our privacy laws and unless we evolve. A reference here and there that's a fundamental right doesn't mean anything.
But Mr. Sorabjee, this privacy law, you think is, time has come that we should have a legislative privacy law in this country so that, many of these gray areas could be taken care of. Because that bill the bill is still there, it has not been introduced in the House, but, the drafts are ready, there have been a lot of discussion on that, but you think the time has come now to bring in a legislation like that?
Yes, the time has come long time back. It's necessary to do it. That exercise must be done, and we must have precise provisions, because right to privacy also cannot be absolute. But then which are the conditions under which can be restricted? Are they reasonable? It must be thought out. I think it's the most important exercise, because administration is affected in one way, the rights of citizens are also affected.
Right.
So they have to properly reconcile by a proper legislation well thought out. And I think we should do that. Of course, in the present parliament we won't do it, but some committee can do it.
Rajkumar,
Also
you
have
think this privacy law, as if you have seen the draft of the bill and things like that, you think that it takes care of many of these concerns?
Well, to me, I think the privacy law should be there. There's no doubt about it. But what would be far more important is the data protection framework, because now we are not. It's not just Aadhaar card. All kinds of data is being generated.
There was a Justice A.P. Shah committee which has looked into it, and it has come out with a report on this.
Yeah, well, because there we are talking about one of the big problems of the Aadhaar card framework is that the way we have collected data, the way we are storing data, the way this data could be shared with people, what are the purposes for which the data that is collected is going to be given. If we had probably taken care of these things at the time of the Aadhaar
should
rollout,
have added legislation.
Absolutely. Well, again, my feeling is, I mean, we have this tendency to wanting a legislation for everything that we do. I personally think we don't need legislation for a number of things, because one of the problems of legislation is that the drafting of those legislations and the scrutiny and test that ought to be going through with the legislation has huge costs involved of a different kind, including institutional costs, including the kind of impact and assessment that involved for a legislation. My point, which is I'm trying to say, is that if we have an effective policy with rules and regulations for implementing that,
you don't need a law,
which will also go through the constitutional scrutiny, because when you're formulating these policies and regulations, it is expected on the part of the government to have that test.
We do need a law,
privacy law, but first, why is it got stuck?
Authorizing,
or no? My question is there any movement as far as this privacy law bill is concerned?
Well, the government set up, Planning Commission set up a committee under Justice Shah that has submitted a report, and certain good aspects of the report, good points of the report have been incorporated in the draft bill. But the government has to take a call. The bill must address, the new law must address the issue of data collection, data storage and data protection. If the government is collecting biometric details, if that is stolen and misused, then they must be held accountable for that. Because after all, it's a question of right to privacy of
Absolutely. I think on that note we need to end. But this is a very important and interesting debate which needs to be held in this country, that what is right to privacy and how much privacy should an individual have, and how much it should be protected. I'm sure there'll be much more debate and discussion on this issue. But what the Supreme Court will finally say as far as the Aadhaar is concerned is something we'll have to wait and watch. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.